Hi, my name's Corinna Lain, and I'm a professor at the University of Richmond School of Law. I write on the death penalty, and I'm here to break down the Supreme Court's recent decision in Bucklew versus Precythe in around 2 minutes. Let's go. Bucklew is a case in which a condemned inmate, Russell Bucklew, suffers from a rare congenital condition called cavernous hemangioma, which causes blood-filled tumors to grow throughout his body, and most importantly for our purposes, in his neck and in the back of his throat. Because of his condition, Bucklew challenged Missouri's use of lethal injection to execute him, showing a substantial likelihood that execution by lethal injection would cause the tumors in the throat and the neck to burst, causing him to choke and suffocate on his own blood. Yikes. The Supreme Court's decisions had said that to challenge a lethal injection, a condemned inmate has to prove two things. First, a substantial risk of severe pain, and second, a feasible and readily implemented alternative means of execution. In Bucklew, the Supreme Court said that it did not need to address the first requirement because Bucklew failed on the second. He failed to provide a feasible and readily implemented alternative that would significantly reduce the risk of severe pain. Bucklew had identified execution by nitrogen hypoxia, a new method of execution that 3 states have adopted and that Missouri's death penalty statute, which authorizes lethal injection and lethal gas, specifically authorizes. The Supreme Court, in an opinion by Justice Gorsuch, said that wasn't enough. The court said, and I quote here so you hear it straight from the horse's mouth, Bucklew has presented no evidence on essential questions like how nitrogen gas should be administered, using a gas chamber, a tent, a hood, a mask, or some other delivery device, in what concentration, pure nitrogen or some mixture of gases, how quickly and for how long it should be introduced, or how the state might ensure the safety of the execution team, including protecting them against the risk of gas leaks. End quote. In short, Bucklew was supposed to answer implementation questions about a method of execution that the state of Missouri authorizes by statute and that other states say would be simple to administer. The result was, as Justice Breyer wrote for 4 dissenting justices, Bucklew presented evidence that lethal injection will cause the tumors that grow in his throat to rupture during his execution, causing him to sputter, choke, and suffocate on his own blood for up to several minutes before he finally dies. The majority holds that the state may execute him that way anyway. And that's my short, sad take on Bucklew versus Precythe. The decision speaks volumes, but it would take much longer than 2 minutes to unpack.